झेपैक इवलिशी सूर्यंबरी इंद्र सूर्यंबरी इंद्रधनु कष्टांचा फुलवणी ओरी विश्वेक शून्यातून निर्मिले परी तेजोमय ज्ञान दीप स्पंदन तरी दिवीजे 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 दिवीजे
Good morning, participants. Please wait for 5 to 10 minutes. We are going to start our session after 10 minutes. Let other participants be joined.
इंद्रधनु कष्टांचा फुलवणी उरी, विश्वैक शून्यातून निर्मिले परी, तेजोमय ज्ञान दीप स्पंदंतरी, दिवीजे 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 दिवीजे.
मनगटात गरुड भरारीतला झरा, अन दिशान भाकरी दिली तपाखरा.
अभिमान ध्येय गोंधळे शिरी, प्रेमळ अनवार मुक्त शारदे परी, झेप एक इवलीशी सूर्यांबरी, इंद्रधनु कष्टांचा फुलवणी उरी, विश्व एक शून्यातून निर्मिले परी, तेजोमय ज्ञानदीप स्पंदंतरी, दिवीजे 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 दिवीजे
Good morning, everyone. I hope you all are safe and healthy in your homes. We need to do best. We need to do best we can do for our own progress. Needless to say, our very existence depend on progress and well-being of teachers as well as students. Therefore, it is necessary for teachers and students to develop their own knowledge. Although I'm sure that nothing can beat a real teacher in the real classroom. So we need to make the most what we can do from what is available. It is necessary for all of us in this today's pandemic situation to adopt blended mode of teaching learning process. It is said that in learning we teach and in teaching we learn. On this note, I, Archana Kamble, Department of Commerce, Naukokan Education Societies, DBJ College, Chiplun, extend my warm welcome to our Honorable Chairman, Sri Mangesh Ji Tambe sir, respective members of Naukokan Education Societies, Principal of DBJ College, Dr. S.S. Bal sir, Vice Principal of Science, Dr. Gawade sir, Vice Principal of Arts and Commerce, Dr. Chanda sir, IQSC Coordinator, Dr. Shilpa Sapre Bharmal Madam, Resource person of today's webinar, Advocate Mr. Chirag Sonija sir, faculties of our institution, and all the participants from various colleges and states on this today's webinar, Intellectual Property Right, Converting Intellect into Money. The main objective of this webinar is to enrich the knowledge of teachers as well as students. In this desperate time, DBJ College Chiplun hopes to create a constructive and comfortable platform for learning for teachers and students. Now, may I request HOD of Commerce and convener of today's webinar, Mrs. Rucha Khavnekar ma'am, to give introductory remark of this webinar. Over to you, Rucha ma'am.
Hello, good morning, one and all. Respected Chairman of Navakokan Education Society, Sri Mangesh Tambe sir, Principal of College, Dr. Bal sir, Vice Principal, Dr. Chanda sir, and Dr. Gawade sir, IQSC Coordinator, Dr. Shilpa Sapre Bharmal Madam, and all dear participants. I welcome you all for today's webinar on IPR, Converting Intellect into Money. Intellectual property is an intangible asset of a person who creates it. The way any other physical asset gives return to the owner of the asset, same is possible from IP also. Rather than it is the only asset which gives returns without making any investment in the form of money. But it's your own idea, creation, thinking, knowledge, intelligence which can generate money. The concept of IPR includes three main components, that is patents, copyrights, and trademarks. Initially, this was practiced in industry commercially, but over the time, it has widened the scope and it is now also applicable to all of us. Simply when we write a book, we write an article in a paper, we publish a paper, or when we record lecture, we upload them on electronic media, or when we invent some new teaching technique, all this come under the purview of IPR, and we need to protect our original work from copying by others. As well as we need to make it very authentic, and we should also be able to convert our intellect into money, which is the prime motto of this webinar. I remember one legal and cultural issue that took place somewhere in the year 1995 when USA claimed patent of turmeric, that is haldi, and government of India had to fought and prove that it is the medicine used in India, which is a Ayurvedic medicine called as haldi. And Dr. Raghunath Mashelkar played a major role in this. He is scientist as well as director of CSIR at that time. And since this traditional knowledge was not properly documented, as well as we were poor at that time about the awareness of IPR, government of India had to hire US legal firm to fight this case. And then India got the Haldi patent. Same is the story for neem as well as basmati rice. But presently, India is among the top 10 countries in the world for filing patent applications. So it really tells us that there is a need that we should understand the legal procedure to protect our intellectual creation and domestically as well as internationally. So this webinar provides a platform to all of us to know the basics of IPR, registration, infringement along with case laws. Webinar will also cover designs and geographic indications. It will also throw light on WIPO, that is World Intellectual Property Organization, and its global IP services. Friends, I feel very proud for overwhelming response from participants from different parts of the country like Delhi, Jammu, Palampur, Rohtak, Chennai, Jaipur, Kurukshetra, Manipur, and so on. Around 250 participants were registered for the webinar, and they are academicians as well as professionals. So there is a mix of all categories of participants, including principal, professors, and students as well. Actually, when we planned this webinar, we were thinking to open this webinar only for the teacher fraternity. But later on, we thought that let our students to participate in the webinar because this is the right age for them and they should be aware and they should also be part of this so that they can explore their ideas and also earn income out of this. And there are also various enormous career opportunities for students. They can also give patent agent exam in this field. So I'm sure that you all will get valuable inputs from this webinar, and the young, enthusiastic, intelligent, energetic resource person will give his best to you. Thank you. Now I request our principal, Dr. Bar sir, to give welcome address. Over to you, sir.
Okay, I am audible.
Yes, sir. Yes.
Okay. Good morning, everybody. I am Principal Dr. Bar. Welcome you all in this webinar organized by Department of Commerce of my college. My warm welcome to today's speaker, Advocate. My friend, into money is not an easy process. It may have legal, social, ethical features. Properly our own intelligence with specialized area through using that intellect wherever, whenever highly required, to converting that wisdom into monetary benefit. Many experts in this concern area may have tremendous intellectual skill, but due to the lack of the procedural knowledge and low level of motivation, they are unknowingly keeping themselves behind. My dear friends, today I am sure that we all will be enlightened from his keynote address. With this very short introductory remark, expressing my good wishes to this program. Thank you very much. Over to Archana ma'am.
For your words of wisdom. And thank you, Rucha ma'am, also for giving this lucid introductory remark. I hope this will benefit to all the participants and society at large. Moving on, now may I request Mrs. Neha Tambe ma'am, Assistant Professor, Department of Commerce, to give brief introduction of today's resource person. Over to you, Neha ma'am.
Thank you, Archana Madam. It's my proud privilege to introduce our today's young and enthusiastic resource person, Advocate Mr. Chirag Sonecha, sir. Sir is postgraduated in Commerce from Symbiosis College, Pune. Sir is also practicing company secretary since 2013. Sir has awarded LLB from Shivaji University, Kolhapur and LLM from University of Mumbai. He is practicing advocacy in criminal matters since 2015 in Sangli Sessions and District Court. He is a member of Library Committee of Sangli District Bar Association. Also, he is appearing before High Court. Sir has completed PG Diploma in Criminal Justice from IGNU. I'm very glad to say that really, sir, you have a diversified portfolio. Sir, you have shown keen interest in computer also by completing BCA degree from Shivaji University, Kolhapur. Sir is also NEC certified market professional level 2. This he has achieved by completing 8 certificate courses in securities market conducted by NEC and BSc. Truly, sir, your profile is inspirational for all of us. I request participant, please put your question in chat box. We will take questions after the session. Now I request our resource person, Advocate Mr. Chirag Sonecha, sir, to take charge. Over to you, sir.
Good morning, everyone. Thank you, Neha, for your compliments. I would like to thank principal, also the organizers of Navkokan Education Society and Department of Commerce, uh, DBJ College, Chipun. Now, moving to our today's topic, that is intellectual property rights, converting intellect into money. Now, what is intellect? What is property? And what are rights? If you decode these three words, you will get a brief idea about today's topic and what avenues you have to convert your intellect into money. I have prepared a PPT. I will share it with you. Host, I request you to, I cannot share the PPT. Please, I request you to allow me to share the PPT. Okay. Is it visible?
Yes, sir.
Okay, fine. Now these three words, today we are going to decode it. Intellectual property rights. First, I will begin with rights, then property, then intellectual. See, what are rights now? Rights means you call it adhikar, hak. If you have right in something, for example, if I am a owner of this pen, what I can do, I can use it, I can enjoy it, I can sell it, I can destroy it, I can do whatever I think fit. So my rights are unlimited as far as I don't encroach into the rights of others. If I'm not the owner of this pen, but supposing I have been given this pen to use it, then my rights become very limited. My rights become very limited. I cannot destroy it. I have been given this pen to use it. So what I will do, I will just use this pen and give it back to the owner. So I'm not getting into the concept of rights which you all know very well. But if you transgress the rights of others, then others will have equal remedy to sue you. Okay. Now, next is property, the second word of our today's program, property. Now, property are of two types, basically of two types, corporeal and incorporeal. Corporeal means those properties which you can touch, you can see, they are visible properties. On the other hand, incorporeal properties are those properties which you cannot touch, you cannot see them, but they are the properties. They are the properties which have some value attached to them. Tangible example. See, corporeal properties are further divided into two types: immovable property and movable property. Immovable property, which you cannot take away from one place to another place. Movable property, which you can easily take away from one place to another place. Examples of immovable property: land, building, etc., etc., etc. Examples of movable property: car, mobile, laptop, etc. Now, today's subject, incorporeal property, one of its branch being IPR, intellectual property rights, which covers patent, copyright, trademark, and many other things. Basically, what are in use or what we can benefit from is covered into basically 3-4 categories, which I am going to cover today, like patent, copyright, trademark, design, geographical indication, trade secret, confidential information. This I am going to cover today. So basically, this is the rough idea of property. Now, you are surrounded by intellect. Today, I am speaking to you. You are at the distance of far away from me. Still, you can see me. You can hear me. This is nothing but a creation of an intellect, a creation of a human mind. Today, you are surrounded by brands. You have Adidas, you have Reebok, you have Puma, you have everything. Crosspen, Ray-Ban glasses. You are surrounded by brands, as well as you are surrounded by intellect. From invention of a wheel, from invention of needle to invention of pen, from cycle, from car, from your watch, from mobile phone, Wi-Fi, from medicines. See, basically what is this? If there were no inventions, supposing, just believe for a moment there were no inventions, then lots of lives would have lost. We could not, today medicines are there which can cure us as early as possible. We cannot travel from one place to another place at a great speed. This is all because of the invention. Then we have telescope, aeroplane, rockets, satellites even. Today we are in a position of discovering the galaxy, universe. This is only because of human intellect. We are studying on the how evolution of human being occurred, when it started. This is all because of our intellect. Then what is intellect? Basically, intellect is a creation of mind. Thus, intellectual property means creation of intellect or mind. It is primarily a thought, an idea, a plan, a scheme, a method to make something new, but something that also includes further step. That is very important to make it possible, to make it work. It should not just remain idea. The idea can be shared without original owner being deprived of the idea. It becomes extremely difficult to detect theft. See, I have some idea. I have an idea, say for suppose today in one click, I can be directly in Dubai. This is my idea. People can have idea. I can share this idea with you. Now today, participants came to know about my idea that on Chirag on one click will be there in Dubai at the fractions of second. This is my idea. But unless and until I don't put this idea into a further step, into my invention, then my idea is of no use. Supposing my family has a turmeric business. Supposing I think of a very interesting brand for my turmeric powder, and suppose I share it with my friends. This can easily be taken away by someone, and I cannot blame him, even though it is a idea of mine, because I have not converted that idea into property. I have not gone a step further. So protection needs to be provided to such thinkers. Yes, protection should be given to me. Protection must be given to inventors. They have burned their midnight oil for coming to an invention. So some benefit they should get and some protection they should get for the hard work which they have taken. So this is the basic concept. So evolved jurisdictions have enacted law on this. What was the purpose of law? Yes, to give some reward and to protect the inventors. So evolved jurisdiction has enacted law to protect intellectual property so as to encourage inventors, poets, artists, business, etc. Intellectual laws typically give owner of an intellectual property the exclusive right to use it. Others are barred from using it without consent of the owner. Now we turn on to patent. Now what is patent? Patents are for inventions, that you keep in mind. Inventions are necessarily for existence and survival of mankind. Today, we can know well about the disasters that are a threat to human being that are going to be there in future. Only because of our intellect, we could detect it prior to the happening of certain events. For example, be it tsunami, today we come to know, yes, tsunami is likely to come. The storms are likely to come, as what has had happened in India in the last couple of days. We were ready to detect the storm well in advance. This was because of the intellect. Hope vaccine on corona, COVID-19 comes soon. Now, essentials of patent. There are four essentials of patent. Very important. First is novelty. Second is non-obviousness. Third is utility. And fourth is enablement. Now, what is novelty? Novelty, you might have heard of novel coronavirus. Novel means new. The invention should be new. It should not be a discovery. If a thing which is already in presence, it was there, you just found it and said, look, this is my patent. No, patent will not be granted to you because it is mere discovery. For example, one new planet, a cousin of Earth called as Kepler 452b, was discovered by NASA. See, there is a difference between discovery and invention. This planet was discovered. It was already there in the universe. It was already there in the galaxy. What we had, what we found? Yes, we found that planet, but it was a discovery. It was not a invention. Okay. So it should not be like reinventing a wheel. Now, supposing you come up with the idea, you create something that does function like a wheel. You put hell lot of designs in it and say, yes, this is my patent, this is my invention. No, patent will not be granted to it. The questions which they will ask you is, what wheel has already been invented. Now, what special you did to add value to it? Supposing a car is there, and in the engine, a patent is granted for an engine because it is an invention. And suppose I develop an engine which saves 50% of petrol, then that engine which was patented prior, then I may get the patent, because by using my engine I am saving 50% of the petrol. So it is adding value. So it is not just mere discovery or mere invention. Okay. So and it should be new. Supposing I go to I go for a tour to America, and from America I find some new gadgets, some new technology. I come in India and say, yes, now this I have invented. No, this was already known. So patent may not be granted to me. Next is non-obviousness. Next element is non-obviousness. Non-obviousness is very simple. Non-obviousness means the inventive step which has not been obvious to any person trained in that field. See, for example, if a mechanic develops a car, now I am an advocate, I am a company secretary, I am in a field of commerce, everything which is related to mechanics is new to me. So I will find everything as an invention. But that is not the criteria for patent, to see whether patent could be granted to that part. Then in that situation, a person from mechanic field should say that that invention is new. The person from that field, the person from another field cannot say, because it will be new to any other person which is not connected to that field. So the person trained in that particular field should say that yes, this is a new invention. Then in that situation only patent will be granted to it. For example, cup noodles. Now yes, noodles are there, Maggie, you all know it. Now I come with a theory, I come with an invention that, see, you pour an hot water into it and keep it for 2 minutes and it will be an invention. No, it will not. It will not be an invention, because everyone is aware that if you pour hot water into Maggie, then automatically you will get the food. Now this is all about
सोनेशन त्यांना अनम्यूट करायला लागेल.
Am I audible now? Okay. I request host to allow me to share screen.
Hello sir, the screen is shared here.
Yes.
Your PPT is visible here.
It is visible, na?
Yes.
Okay, okay. So not non-obviousness.
Right.
Yes.
No,
Right
no,
side.
non-obviousness means a person in that field should be aware that yes, for me also it is new. Then now we turn on to our next slide. Utility. There must be some use. There must be some use. If a thing is invented by me and suppose it does not come to the use of any person, then patent will not be granted to me. For example, see, the contra pills are there to avoid abortion. Now if in a country, contraceptive pills, if in any country there is a law which says you cannot use that pill, then in that situation, even though I had made an invention in that country, I will not get a patent because it will be of no use to them. I may get patent in any other country, but I may not get a patent in the country where there is ban on it. And suppose I make an invention which, yes, if it is supported by the laws of that country, then even though there is a, am I audible now? Okay. There, then my thing, my invention will get patented. Now to the next slide. Enablement. Enablement means I should be, see, it should not be a mere idea. I should let specifications. I should make the patent office believe that yes, these are all the specifications. This is the method of using that patented article. I should be ready to explain it. Only when I will not be able to explain it, when I have just made it an idea, but I have not converted my thought into process. In that case, if I am unable to give my complete specifications, then I will not be granted a patent. Okay. It must be operational, in short. Now, next slide is types of patent. Now, ordinarily, there are two types of patent. One is ordinary patent, which will come for inventions. And second is a patent of addition. Patent of addition means to that product, I am adding something new, increasing its ability. For example, Apple 6 have come, then Apple 6s, then 7. See, I'm adding it to the existing product. Then in that situation, it will be patent of addition. To the next slide. Patent registration. Patent registration is the process which I have prepared a different slide. I will share it with you all. See, we have to just make an application. We have to just make an application to the patent office. We have to give complete specification, or we can give provisional specification at the earlier stage, and that complete specification within a certain period of time. Then they will scrutinize our application. They will scrutinize. They will see whether the 4 basic elements of patent are present in my invention or not. Whether it is a discovery or an invention. If I satisfy all the criteria, then yes, patent would be granted to me. Next slide. Duration of patent. Now, what is the duration? 20 years from filing the application. Thereafter, it goes to public domain. This is very material. Patent. Today, I have made some invention. Then in this situation, my patent will be for 20 years from filing date of application. And then after 20 years, it will go to public domain. Then anyone can use it. Then anyone can exploit it. 20 years, I will enjoy the royalty. I will enjoy the fruits of my invention. Next slide. A patent cooperation treaty. This is very material. Why is it material? I asked to myself, if I have made an invention, I'm in India. So what I will do? I will file my patent application in India. So I will be protected in India. But what about other countries? Anyone can take up my idea and file patent application there. So the basic concept of patent cooperation treaty is that if I file a application of patent under this treaty, then my patent would be protected in every country who are the members of this treaty. It is basically a multilateral agreement. So I will be protected in majority of the countries. No need to simply file application in first India, then America, then Europe, each country. Simply file a patent application under patent cooperation treaty, and you will get your patent registered. Next slide. Examples, yes, of patent. This patent webinar on patent would be incomplete if I don't take the name of Thomas Edison, who had more than 1,000 patents in his name. But he tweeted, he said, my electric light invention has brought me no profit, only 40 years of litigation. Edison spent more than 2 million USD in late 1800 in patent litigation for a bulb, electric bulb. 3 idiots in his name. Next slide. Okay, case study. Yes, what is the importance of patent? Who can forget the next slide? Okay, this is a landmark case. Novartis case, as it is called, a very popular company, a multinational company, a Swiss company, Novartis, filed a patent application in Chennai, was dismissed. The application was rejected, then appealed, matter reached to Supreme Court. Supreme Court, it was an anti-cancer drug. Patent was filed for it. Now, when the matter was in Supreme Court, it was noticed that there was no invention in it. This product was already in the market, only just a mere something was added to it, but the substantial part of the product was there, and it was there in the market, available under different brands of different company. Then in this situation, Supreme Court, yes, dismissed the submissions of novelties and said, no, you have not done something new. What you are coming with is already known to the public at large. And in this case is very important. Why? Because in this, Supreme Court has also said that, see, India means it is not that people are poor here. Majority of the people are poor here. And if a monopoly is created in such a way, then it may be abused. See, the concept of patent is that you get a monopoly for your invention. You can enjoy royalty from it. But what if that monopoly is exploited? You sell a 1,000 rupee drug at 50,000 rupees. You can, because no one is there to compete you. You have got patent for your invention. So there is a provision called as compulsory license. I don't know I have covered it or not, but compulsory license. In this compulsory license, government or the third person can apply. They can take away the patent rights given to you, and they can give it to some third party to manufacture that product. That is called as a compulsory license. Next slide, please. Now this is the same. These are the issues which were before the court. Next slide. Am I audible? No? Next slide. Good. Now copyrights. So I have not covered this compulsory license issue, which was very material, to have a check or keep check on the proprietors of invention. Suppose there may be there were cases. I have made an invention, but due to my contacts, small contacts, I am not able to sell it in the market. I'm not able to sell it in the market. In this situation also, compulsory license may be given. Now copyrights. Okay. Next slide. Copyright means rights of copying, literary work, cinematography, drama, books, films, paintings, photographs, music, poetry, dance, drama, computer software, article, journal, all covered within the definition of copyright. Symbol is like C. You must have been, when you refer to any book, on the first page, you come to see this symbol. Then you have to keep in mind that yes, this product is copyrighted. You cannot copyright it without the consent of owner, without the consent of those who has created it. Next slide, please. Okay, see, this is very material. Why this is material? Because the crux of the copyright is only expressions are copyrighted, not the idea. See, copyright protection is provided to the expression of the idea and not the idea itself, not protected. This is the fundamental principle of copyright we should keep in mind. Fundamental principle of copyright law is that idea cannot be protected. The only expression of such idea can be, and there may be number of expressions to the same idea. Now I will give you a beautiful example which I like the most. Now there is a song, ये चांद सा रोशन चेहरा, जुल्फों का रंग सुनहरा, sung by Mohammad Rafi. Actors were late Shami Kapoor, a beautiful dancer, and a beautiful lady heroine Sharmila Tagore. The scene is at Dal Lake, and the film was Kashmir Ki Kali, released in 1964. ये चांद सा रोशन चेहरा, जुल्फों का रंग सुनहरा. Can you play this? I have set a link there. See if you can play it or not. At the bottom, no, this not. On the previous slide, there is a link at the bottom, left, right hand side, extreme bottom. Is it getting played or not? Okay, do one thing. Please allow me to share my screen so that you would be able to understand. You close this and allow me to share my screen. I will open it on my laptop. Okay, thank you so much.
Share screen बराबर. Yes sir, wait a second. We are.
Host disabled. Okay, yes.
Yes, we are allowing you.
Thank you. Now it is visible
yes, sir,
or
yes,
not?
Sir. Yes, sir, it is visible.
Yes, okay. Utility, okay. Types of patent, duration. Now we are in patent cooperation treaty. It is visible. Which slide is there?
No. It is the first slide which is only visible. So you please run the
double click on that.
Just click, double click on it, and if possible, just make it a slideshow.
Yes. Okay. Copyright. It is visible.
No, sir. Still, the first slide is only visible.
1 minute. 1 minute.
Yes.
Okay, I have opened it.
Yes, sir. It is getting opened.
First slide, right?
Wait a minute, sir. It is opening. No, sir. Only first slide is visible.
Yes. Now turn to second slide.
Please right click on that file.
Just right click on that file.
Okay. See, I am in 1 minute. Now copyright subject, right?
Only the first slide is visible still.
Wait, I will. Now first slide, right? It is changing, na?
No, it is only first slide.
Okay. Wait, I will stop sharing.
Yes. Stop and then resume again. First open the slideshow and then share the screen.
Yes. 1 minute. I'll close everything.
Yes. Okay.
New share.
Yes, sir. Now just put it into the slideshow mode and then play the sound. Yes, now it is visible.
Yes, thank you. Just see where I am. Copyright law, right? And current slide. Now we are in Copyright Act, right?
Yes, sir.
Yes. Now second slide, which I have covered.
Yes.
Now the third one, copyright.
Yes.
Okay.
Copyright.
See, now I was telling only expressions are copyrighted, not the idea. There may be number of expressions to the common idea. The best example which I found is Ye Chand Sa Roshan Chehra. This song you all must be aware of it. I will play for you. You are hearing, right?
Yes, yes, sir. Yes, sir. It is audible.
Now, see in this, the Shami Kapoor ji is comparing heroine with the face of a moon. Ye chand sa roshan chehra. He is comparing the face of the beautiful Sharmila Tagore with that of a moon. Ye chand sa roshan chehra. Now this is the expression. This is a expression and an idea. Idea is of comparing one's beloved with the moon, and he has expressed it through Ye chand sa roshan chehra. Now supposing for a moment if we copyright this one, then in this case no other person will be able to compare his lover with the face of moon if this is copyrighted. So idea cannot be copyrighted. Expression Ye chand sa roshan chehra, if I use it, then I will infringe copyright. But if I express it in other word, then it will not be copyrighted. Immediately next year, in the next year, there was a film wherein Himalay ke God mein, released in immediately next year 1965, wherein a face of a lover was directly compared to the moon. Okay, so here also chand si mehbooba ho meri, he is comparing beloved to the moon, but as expression is in different form, then it will not breach the conditions as laid down in Copyright Act. There will be no infringement of the copyright. Okay, next slide now. This is also one of the interesting cases, Naruto case. Naruto was a monkey, and one photographer, David Slater, he went to the rainforest for photography. He found a group of monkeys.
Sir, excuse me. The slide is freezed on copyright only. So can you please?
What he did, he placed his camera, and his case is that one monkeys from that group, they took down their own selfie, and this is it. One picture of it was.
Hello, sir. Sorry to interrupt.
Hello.
The slide is freezed on copyright only. So can you please just press escape and then put it into again the slideshow?
Copyright. Did you hear the songs?
Yes. The song
okay.
was
both the songs, na?
Yes.
Okay. Wait. Now. Okay. This you can see the monkey.
No, the slideshow is actually freezed on this side. So can I share from my side the slides?
Yes,
so
definitely. But what the problem is?
Yes.
Hello.
Yes.
The problem is you will not be able to play the videos. So I am telling you.
Okay,
I will only.
Just it is freeze somewhere. So just press escape on your keyboard.
Yes.
So that you will get out of this.
Yes.
And can you please just reshare your screen? Yes. Now it is visible. The monkey will.
Monkey is visible, right?
Now just
Yes.
from current slide.
Yes.
Yes, it is
Right.
visible. Okay, sir.
Okay.
Yes, sir.
Thank you.
Okay.
Now this is a monkey photo. A British photographer named David Slater went to a forest, and his claim is this monkey took down his camera and clicked on the selfie, and this was it, a selfie by a monkey. Now there was hell lot of mess. The Wikipedia, the encyclopedic website had posted these photographs on Wikipedia. He filed he disputed it, but Wikipedia claimed no, monkey cannot have copyright. Monkey cannot have copyright. These pictures are still there in Wikipedia. Now this case took a new turn when an NGO, a popular NGO, PETA, filed a suit for getting copyright in the name of monkey, Naruto. Now, question before the court was, how will a monkey will be the owner of copyright, and how will it give the authority to file PETA on its behalf? This is the question, quite interesting case. Then in this, unfortunately, the plea of the data were dismissed at every forums, but the highest court, when the matter reached the highest court, unfortunately, there was a settlement between David Slater and PETA. David Slater said, I will give you a part of my royalty to this PETA, which can use it for the forest in which Naruto was living. Okay. Now the next slide. So this was the splat with Wikipedia and Naruto case. Yes, case laws. Now RG Anand versus Deluxe Films. Can you see it? RG Anand versus Deluxe Film. Yes. Now this slide is getting further, no?
No, only case law slide is present.
Yes, I will do one thing. Case laws, yes. Case law slide is there.
Yes.
And now you find RG Deluxe versus Deluxe Films.
Yes. It is present on text.
Yes. Now this is also a landmark case, and in this, court has distinguished between what is expression and what is idea. Hum Hindustani drama was there, and it was shared. A film was made called New Delhi on that, but there were substantial new things added to a film New Delhi. Matter reached court, and court ultimately stated that no, there was substantial improvement. He has not expressed the film as it is, so there was no infringement of your copyright. Same is the case of one famous case, Adobe and Microsoft. You must be knowing. These both companies prepare software. Now, one of the software falling in the meaning of literary work. One call center was there, a startup's call center, which used pirated version of those software, in which court said, no, this is bad. You pirated the software. Pay 5 lakh compensation and 5 lakh as punitive damage to them. Okay. Next slide is there, na? Registration, copyright registration.
Yes, sir.
Okay.
Yes, sir.
Copyright registration, you have to simply make an application. See, registration process means you have to make an application. The registrar will see whether previously such type of copyright is registered or not. It will publish it for objections, and if there is no objection or the objection is untenable, then a registrar will get satisfied, and then it will decide the case in your favor, and copyright ultimately will be granted to it. Copyright duration is normally for 60 years. 60 years, life of the author plus 60 years. Always do remember this, life of the author, then further 60 years from that. Then one whose name cannot be traced out, one author who is dead, then in this situation 60 years is given. Now we will turn to trademark, right? Trademark is appearing na? Okay. Now trademark which you can use and which you can convert it into money. Today you are, as I told earlier, you are surrounded by brands. See, you have money to purchase clothes and you have two brands in front of you. One is Raymond and second is a brand of Chirag Sonecha. Which brand will you choose? Of course, Raymond. Then you have money to purchase watch. You have two options. One is Titan watch and second is Chirag Sonecha's watch. A brand called Chirag Sonecha. You will but obvious choose Titan. You have money to purchase a car. You are thinking of purchasing a car. You have two options, Jaguar and second is Chirag Sonecha brand. What you will choose? You will choose Jaguar. And shoes, Bata or Chirag Sonecha, you will choose Bata. Goggles, specs, Ray-Ban you have on one side, having same money factor being common, and Chirag Sonecha, you will but obvious go for Ray-Ban. Why is it so? And now here you are, a complete man. Now, why is it so? What trademark does? Trademark lets you know the origin of the product. Ray-Ban, who has made it? Who is the owner of the trademark? You come to know the source of the product. Who is the person behind it? Who has made this product? And it also guarantees the quality. Ray-Ban, they are selling goggles for n number for decades. No one has complaints from them. And Chirag Sonecha brand is somewhat new. So in this case, this product assures quality. The trademark assures quality. Hence, you get value assigned to it. We will do one experiment. Are we on the page of experiment? You are visible? You are seeing the experiment page? Let's do some experiment. Now, there is one wallet. Can you see the wallet? Okay. There is one wallet. Now, this doesn't have any brand. Now, the price will be around 100, 150, 200 say. Now, this is me. Now, I have got an idea. What I do? I think of a brand name, Puma. And what I think? I have spent a lot of money on advertising it. From decades, I am selling it. What I do? I just paste my brand here on the wallet. Simply by pasting this brand, now the value will be, don't know how much, 500, 700, Amazon it, Google it, and you will let it know. Now, trademark protection is a statutory protection which extends to a mark capable of being represented graphically and capable of distinguishing the goods or services of one entity of those of another. See, when you stick Ray-Ban on the goggle, you come to know the source of the product, the maker of the product. So it distinguishes the goods of one person from that of the another. It may include shape, packing, color combination, logo, symbol, word. Just imagine Kirloskar written, Reliance written, Kingfisher simply a bird. Everything comes under the definition of trademark. Now, best trademarks are, what are the best trademarks which are short? Nike, Levi's, very short. Puma, very short. Dell, easy to pronounce. Should not be very what you call very difficult to pronounce. It should fit in the minds of the customers. It should go into the brain of the customers. So it should be easy spelling. I went it wrong. It is easy to pronounce, easy to spell. And the best trademark is which is totally unrelated to the product. Now I cannot, which is totally unrelated to product. We'll go for example first of this. See, for Apple for mobile, totally unrelated. Apple B, it is a fruit. It is given to mobile, totally unrelated. Diesel for t-shirt, Puma for shoes. So it is totally unrelated to the product. In this case, you would be easy to identify it. See, for turmeric, if I give the name Haldi, then it will cause confusion in the mind of people. This trademark will not be granted to me. I cannot use flag of India as a trademark. I cannot use national emblem symbol as my trademark. There are some exceptions. I cannot use super quality as trademark. See, it denotes directly a quality. It does not distinguish your product with that of another. Your trademark should not be identical. Section 9 of the Trademarks Act 1999 speaks about identity of the trademark. What is identical? As it is. As it is. Suppose I copied that brand name Tata as it is, then it will be identical. And if I say Taba, I just changed one word, one letter, one alphabet. In that situation, I will be a similar trademark. Section 11 hits. So my trademark should not be identical, means as it is, and similar means going towards it. Say Reliance is a trademark, and now I start a firm called Reliance. Reliance Reliance. Telephonically near to similar. Then in this situation, patent this trademark may not be granted to me, as I am trying to pass off the trademark of another person. It should be distinguishable. Then well-known trademarks. Now you must have heard about Xerox. You say, भैया Xerox कर दो, 4 Xerox लाके आओ, 4 Xerox दो. See, the brand has got so much reputation that the real word of copying something is photocopy, not Xerox. But you have now fit in the brand name Xerox has put in your mouth. The Xerox company actually manufactures machine for photocopying. It manufactures machines which photocopy the paper. Now for photocopy, you are in your day-to-day life using the word Xerox, 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 Xerox. This strength the trademark has. Bisleri for water bottles. भैया बिस्लेरी दे देना. Even that shopkeeper gives you different bottle, you don't have any concern of it for it, still you say भैया बिस्लरी है क्या, सर बिस्लरी है क्या. So it has been a substitute for water bottle. Such has been a branding of the Bisleri. Then some other well-known trademarks. Well-known trademarks are those wherein a substantive population of a people have know it. See, Tata, everyone knows. Now, why I am telling you about well-known trademarks? See, basic concept of trademark is in trademark there are classes. Trademark has some classes. Classes are bifurcated into products and services. For haldi there is a different class. For chappal there is a different class. For water bottle there is a different class. For construction there is a different class. For accounting there is a different class. So if Chirag is registered for turmeric, for spices, some other person can definitely use Chirag trademark for chappal, because I have registered my product for turmeric only, and he is registering Chirag trademark for footwear, a kind of a very different product. So in this case, trademark may be granted to that person, but this is not the case for well-known trademarks. When a trademark is well-known, then no one from different class can use it. Now, even Tata is not there in turmeric making. It is there, but as a matter of example, if Tata brand is not there for turmeric, and if I use Tata, then I will be violating the provisions of Trademark Act, because I am copying a well-known trademark. Reliance, there is a concept of collective mark. Collective mark means a mark for a group of marks. Say example, Brook Bond. Brook Bond is a collective mark for Red Label, Beat, Taj Mahal, Taza. For all these brands, there is common Brook Bond brand. This is a collective trademark. Certification mark. See, certification mark is quite different than trademark. Like wool mark is there, ISI mark is there. Wool mark means the product is of 100% wool. ISI mark means it is granted by Bureau of Indian Standards, which meet the requirement. The mark, certification marks certifies that the product meets certain standards associated with the mark. Now, trade dress. Now, this is also a very new concept. What is trade dress? Now, corporates think beyond it. This is a, can say, a new branch of intellectual property which is evolved in about a decade or so. Trade dress. Here you do everything. You use color combination, you use sitting arrangement, you use furniture, same in all your branches. You give common t-shirts to your employees. See, Airtel has Vodafone Zuzus. Color combination Airtel, red and white. Idea, blue. They keep on harping on yellow Idea. So when there is a yellow logo, immediately it is clicked that yes, this will relate to Idea. This is a trade dress. Now this restaurant I visited, this is in Pune. In a mall, this restaurant is there. Jungle restaurants. They have series. They have franchises of it. You will find in many metropolitan cities. Literally in a mall, when you go inside, you will feel like you have come to a jungle. The theme is like that only. Sitting arrangement, then there is a waterfall, some animals, the artificial animals are there, leaves, trees are there, artificial. So they have created an environment like jungle. So this is a concept of trade dress. Now registration of trademark, same. Registration is very simple. Just take an application fees, give it to the trademark registrar. If they have any objection, they will raise objection. If your product is a national emblem of India, for example, then directly they will say no, as it is hit by section 9. If your product is identical with the mark of other person, then it will be hit by section 9. It will not get registered. It is similar. Tata Bata. Jara ajubaju in spelling or in telephonically. Then in this situation, a notice under section 11 may be given to you. If you satisfy, no, my product is different, my trademark is different, then the trademark will be granted to you. Or else, supposing you are the honest user, you are not knowing it, that there was a similar trademark existing prior to the filing of your application and using of your application. In that situation, you can very well request the registrar for imposing certain conditions. Supposing there is a brand in New Delhi, and my brand, I am located in Maharashtra, I have a business in Maharashtra, and my brand, I have created one brand after the brand which was created in New Delhi, and I used it. I started using it. Later on, I went for registration of the trademark. Section 11 notice was imposed. I can very well request the registrar that impose condition on me so that I can use the trademark in Maharashtra only. That fellow, that other person is from Delhi. His market is limited to Delhi or some other states. I will not use my trademark beyond Maharashtra, or I will use my trademark in 2 or 3 states. Please grant me the trademark. So conditional trademark may be granted. Trademark will be published in Trademark Journal for 4 months for someone to object on it. Then duration of trademark is 10 years. Design also 10 years. Geographical indication also 10 years. So 10 years, it can be renewed by paying renewal fees. That makes it almost perpetual. Trademark is like a diamond that lasts forever. Trademark, case on trademark. This is a very, very interesting case. Benz. When I take up this name, you will immediately come to know. Benz, Mercedes-Benz, a dream car. Everyone would like to purchase. And second is a famous brand, a well-known brand. Now what VIP undergarments did, a very famous case. VIP undergarments came up with an advertisement like this: VIP Benz. A man in a ring stretching his legs. Similarly appearing as a trademark of Mercedes-Benz. Delhi High Court came heavily on VIP Benz. It ordered injunction stopped the sale of VIP Benz undergarments. Not only this, under this trademark, and not only this, it also rejected a prayer of VIP undergarments Benz for even disposing of its existing stock. Other cases of trademark, see, glucose D, glucon D. Seeing this, I am only confused which is the original and which is the not. Daily milk. For dairy milk, daily milk. Starbucks, a very famous coffee center by Tata Alliance, and this is Starbung. McDonald's, a very famous M, and McDowell's, copycat. So in this situation, mark cannot be registered. Now this is a concept of passing off. Now you will say, you will ask a question to yourself that my mark is not registered. I am using it from generations. My grandfather used to use it. My father used to use it. I am using it. But I have not registered. And now a person has come and he has applied for registration, or he has been using it. Now you are a proprietor of unregistered trademark, but you are using it. Some protection must be granted to you. Merely because you have not registered does not say that your rights are infringed. In this case, you have a relief under equity common law, wherein you can still file a suit, claim damages, and this is a passing off. But you have to prove that other person has passed off your rights. See, I will read it. Action of passing off is to restrain the competitors for passing off its goods or services to the public as that of pre-existing manufacturer, or service to the public as that of a pre-existing manufacturer or service provider. It is an action not only to preserve the reputation of the latter, but also to safeguard the public. See, my generation, my forefathers are using that brand. It has become, though not registered, it has been in the mouth of the public. Public are taking the product only because it belongs to our family. So merely if someone starts using it under the guise that I have not registered it, then I need to be protected by some law, and this is the law of passing off. The second important element of passing off action is misrepresentation. The other party should misrepresent, which may be intentional or innocent. The real test is establishing the likelihood of confusion in the minds of actual or potential customers or users. These customers are not expected to have extraordinary memory. Thus, the test is imperfect recollection of a person of ordinary memory. हाँ, कोई भी गाँव वाला है, गाँव वालों ने देखा, उनको पता नहीं चलता. ऐसे नहीं है कि you should bring microscope and bring it. Yes, there is a difference. This is not so. Only on looking at it, like glucose D and glucon D. On looking at it, ordinary man can be confused. The third essential element of passing off action is loss or likelihood of it. As I am having, my fathers are selling turmeric from 4th generation, my family, and some new person comes and uses my logo, then I can very well drag him to the court under the law of passing off. Now, domain name, I will not go much into it, but you can very well create your own domain name, and there is always a dispute. See, I can tomorrow, if tata.com is available to me, what I will do, I will register it. And Tata brand name, even if is a well-known trademark, I am paying the fee for tata.com, then they cannot do anything. They have remedy, but still chances are there that they may fail. So .com, .edu, .info, .net must be simple, protected. And there are very mischievous persons like Google. They do Google or Gogle. They take the advantage of spelling mistakes and register it. Supposing in typing someone goes wrong, they will kind of directly connect to their .com. You can very well experiment it. They are this GOOO are available. These sites are registered under domain name Yahoo YAHO.com. People may do like this. See, getting domain name. See, it is also a tact. If you book a domain name and if you don't renew it, you will immediately find the next day someone has borrowed it. These are mischievous people who know in after 2 or 3 years, or maybe after some times, you will be back searching for that again, the domain name, and they will quote you much higher prices. They will sell you. They will not keep it with them. So now design set. Now design, you must be knowing, you must have had this little hearts design. What meaning the design has? Little hearts. See, this is a design which is registered. Now see the product. If this heart would have been square, this heart would not have been there. The company claims that if you keep this heart in your mouth, it will melt and it has a delicious taste. Now, supposing this heart is not there, what difference would have it been making? But designs are equally important. The companies focus on it. They spend a lot of money in inventing new designs. You can immediately recognize Mercedes car coming by their headlights. Two headlights, one big, one small, close to each other. This is all because of design. The design appeals solely to the eyes. A design which is functional cannot be registered under Design Act. The purpose of design law is to provide protection to the originator of new design. This is very important, so that he is not deprived of his reward if others apply this design for their goods without the permission. So design should be new. Design already there somewhere around the corner of the world, I cannot use it. Now a design can be registered only when it is new or original and not previously published in India. It must be a new shape, configuration, pattern, ornamentation, or composition of lines or colors applied to such article in any form by industrial process. It does not include any trade or property mark or artistic work. Protection is given to the design and not to the article itself. This you remember. And the difference between trademark and design, the fundamental difference between trademark and design is that former singles to the mind the source of identity of the manufacturer of the article, whereas the latter appeals to the eyes and attracts the customers directly. Looking at the design only, you will find it attractive, while the trademark, who has manufactured that product, this is the work of trademark. The company may like to opt for both such protections. However, company cannot use the same mark or a peculiar design for a trademark as well as a design protection. The moment there is a functional element involved, the design aspect goes away. Registration of design, again an application with the free fees. Department does scrutiny. Novelty means it should be new, it should not have been used previously. If that is so, then you will not get design. Duration 10 years. Geographical indication. Just Emma, this slide, whether it shows geographical indication of goods, just let me know. Yes. Now geographical indication. You must have been heard of Tirupati Laddu or Kolhapuri Chappal or Darjeeling Tea. Darjeeling Tea rather was the first company. Darjeeling Tea rather was a first company who which applied for geographical indications. Geographical indications makes you know that a product belongs to some geography, some part of some locality, the place from where the product has been. But it is not necessary that the product should indicate the place. That is very material. Now, Tirupati Laddu, of course, it says about Tirupati. Then Kolhapuri Chappal, Kolhapur. But there are cases like Basmati Chawal. You don't know the origin. Basmati Chawal that smells, that has aroma in it. So in this situation, geographical indication may be granted. Scotch whiskey. Scotch, it is a place. Tequila. Champagne. Swiss watch. Unfortunately, in India, very few, this concept of geographical indication has come very late. France was the first to recognize the importance of geographical indication. They have made huge amount of revenue out of using the geographical indication. It is important here to note that an individual cannot apply for geographical indication. Application should be made by association of person or a body, a group of person, saying that yes, in this locality, the product is different and famous. We want this to be registered under geographical indication. By using it, by giving the registration, any person who manufactures that product there can use the geographical indication stating that this product belongs to that place or that group of association. When you see of Swiss watch, you immediately come to know Swiss made. Somewhere it has connection with Switzerland, and the watches are the best watches in the world. Basmati, you have big rice. Alfonso mango. Okay, see, Mysore jasmine, Coorg oranges, Mysore silk, Dharwad pede. Okay. Now registration, see, GI is not compulsory to get protection. Even unregistered GIs can get the protection of the common law of passing off. However, it is always advisable to register a geographical indication because such registration is the best prima facie evidence in case of any infringement. Registration is not compulsory, as that thing is become famous there. I am from Sangli. Sangli, when you just imagine of Sangli, you come to know about turmeric. Yes, turmeric, many businesses are there. It is known as a land of turmeric. So it may be geographical indication of Sangli. Though not registered, registration is not compulsory, but if someone uses it, then we can very well drag them to the court of law. GIS cannot be registered as a trademark. If it is, it cannot be registered as GIS. There are 34 different GI classes based on products and product categories. Classes under which goods can be registered, and the same item can be registered in more than one class. For example, see, woolen shawls for a particular region may be registered as wool for that region, and also embroidery for that region. In Sangli, suppose wool is famous, wool shawls also can. Solapur is famous for other these things. So Solapur, I will give example of Solapur. Solapur shawls are famous. Then wool can be registered for that, and also embroidery. Moving to the next slide. Procedure of registration, application by AOP. See, individual is not there, or a producer, or an organization, or authority established under the law should make an application to Controller General of Patent, Design and Trademark. See, this is common for patent, design and trademark. Advertisement, opposition within 3 months. If no opposition received, and if opposition is received and it gets decided in your favor, then registration will be granted. Appellate board is also there, same as in trademark. Duration 10 years and can be renewed. Trade secrets. Now you know Coca-Cola formula. Coca-Cola, what Coca-Cola says, what Coca-Cola claims, that our formula is secret. Only few people know. Now this is the secret of our success. No one knows it till today, whether it is what you call it as a formula is secret or not. Till today, Coca-Cola claims that our product has something special, some secret in it, and we are not going to share it. Whether, see, secret, what is the secret? Whether it is secret or not. Do you must be knowing a famous just let me know someone turn off the mic and say whether trademark and one screen is visible or not. Please someone turn off the mic and say whether the one screen is visible or not.
The screen is visible, but it is black.
Yes, that only I wanted.
Yes.
See, then the trade secrets, whether that very part is secret or not is the question. Now you all must have been you all must have seen a famous movie called Kung Fu Panda, released in the year 2008, where there is a dragon scroll, and this Po, a big Po, who believes that while reading that dragon scroll, he will get endless powers. Master Shefu also believes that when one person looks at that scroll, he will get endless powers. This was the secret. What is the secret? Let's see that episode, and you will come to know the importance of trade secret. I'm playing it. Now, this is a dragon scroll. A secret document. Video play होते ना, video play होते. Now here is secret. Blank. There is no secret at all. So see, this was blank. It was a secret. He says that it was kept. This scroll was kept from many years. No one has looked at it, and so when one looks at it, it will get endless powers. Now see the next slide.
I'm sorry things didn't work out. It just wasn't meant to be. Oh, forget everything else. Your destiny still awaits. We are noodle folk. Blood runs deep through our veins. I don't know, Dad.
Now here he reveals the secret.
Sometimes I can't believe I'm actually your son. Paul, I think it's time I told you something I should have told you a long time ago. Okay? The secret ingredient of my secret ingredient soup. Oh. The secret ingredient is nothing. Huh? You heard me. Nothing. There is no secret ingredient. Wait. It's just plain old noodle soup. You don't add some kind of special sauce or something? Don't have to. To make something special, you just have to believe it's special. There is no secret ingredient.
See, every customers were buying that noodle soup, that product, only because it was secret. At the end, his father only says, we were making the soup and telling the customers it was secret, and the secret was nothing. So Coca-Cola says it is secret ingredient which they use, but it may be or may not be. They know it. But once that secret is out, the very protection of trade secret goes away. That is very material to understand. If someone comes to know that there is no secret at all, then there is no similar law. See, there is no law. There cannot be any law on trade secrets. If a formula is disclosed to someone, at the moment it is disclosed, it will not remain secret. So there is no similar law in India, and confidential information and trade secrets are protected primarily with the help of contracts. See, if Coca-Cola gives something to manufacture to its sister company or to a third party, you manufacture Coke. Now, in that situation, if trade secret, if Coca-Cola company wants to protect its trade secret or a confidential information, then it will write a contract that, see, we are sharing with you secret. Please don't share it with other person, or else we will sue you. We will recover damages and loss for sharing such information. So primarily, these trade secrets and confidential information will get protection if there is with the help of contracts. In the absence of explicit contract, protection is provided on equitable grounds. See, duration of trademarks, as I told, once you say something, then there is no secret at all. Second, one interesting thing about confidential information also. Confidential information itself should be confidential. Supposing I say to my friend that Delhi is the capital of India. What is secret in it? Nothing. What is confidential in it? Nothing. All are knowing it, so this will not come under the definition of confidential. This is one important fact we should understand. Now, it can be kept secret till the time it becomes public knowledge. The moment it is disclosed, the protection is lost. However, if a person finds trade secret or confidential information by independent discovery or reverse engineering, that person is not able for prosecution. For example, this is my example, Maggie. Maggie, the moment I spell Maggie, there is water in your mouth. Maggie magic masala. What I do, I just tear that magic masala powder, and what I do, I look after that ingredients by the reverse mechanism. If I come to know the formula of it, then it is no more secret, because I have done reverse engineering on that. I have done my own research on that. And this see, be it trademark, be it patent, copyright, everything, it can be licensed. I can assign it to anybody. The confidential example, the example I told you, and this is Diljit Singh case, Titus and Company, very famous case for advocates. A law firm called Titus and Company was found in 1996, 1997. Diljit Titus was the main person. He is known for the collection of the cars. He was the main. He had 4 associates. These 4 associates left the firm somewhere in 2003, 2004. One of the associate, what he did, he went to the company, he copied all the information of the client in CD. He copied all the visiting cards, around 3,000 visiting cards he copied. He copied all the formats of the application which we submit in the court of law. Now, Diljit Titus, late Shri Finance Minister Arun Jaitley ji was representing Diljit Titus. He said, Diljit Titus sued that 4 associates and told to immediately give back the data, stop using those data, and stop contacting those clients. On the other hand, the associates, they took up a defense that this all were made by us. We were the associates. We have made all this. There is no question of copyright or breach of confidential information. On the other hand, Shri Arun Jaitley ji, who represented Diljit Titus, said there was no contract, but there was a binding in the capacity of a fiduciary duty. They were associates. They were under obligation. They were under duty of, they were working under Diljit Titus. Hence, there was a breach of confidential information. In this case, court decreed in favor of Diljit Titus and said, yes, there was an implied confidential information agreement. Next slide. Traditional knowledge. This traditional knowledge, India. You know, in India, if you get some those who have grannies in their home will be aware of this fact. कुछ लग गया तो दादी बोल देगी ये लगाना है, गिर के आए तो हाँ उधर हल्दी लगा देना, बुखार आया तो नीम के पत्ते का थोड़ा उकाला पी लेना. We have remedies of everything. Granny says all the traditional methods which we used to do. गैसेस हो गए तो हिंग लगा देना. But see, this works. This knowledge works. This India has applied this knowledge from time immemorial. That's why it is called as a traditional knowledge. This knowledge is useful. There were effects of this, positive effects of this knowledge, but under this was an invention, can call it as an invention of the properties of some product. What others did, they took the advantage of it, filed a patent application and got patent registered in their name. This was the same. Neem example was given in the introduction only. Speaker said turmeric example, the patent was granted to it. India came to know later on, अरे ये तो हमारे कंट्री में पहले से चला आ रहा है ये सब, इनको पेटेंट कैसे मिल गया? How they got the patent? Our forefathers knew this, so this was already existing. There was nothing new. There was no novelty in it, non-obviousness in it. Hence, India opposed it. Fortunately, India won this. But India learned from it. They started creating a digital library. Very difficult task, as languages are different. Tamil people may be knowing some new formula for illness. Maharashtrians, new formula for illness. Calcutta, new formula. Bengali people, new formula for illness. So this is all the knowledge which we are codifying now. This was uncodified, and unfortunately, this was never brought on paper. Manuscripts also contain some remedies, some formulas which can cure diseases. The knowledge may be with regard to the use of natural resources, environment, plant and animal, curing disease, or nature in general. The most of the knowledge is undocumented. So first case was a neem tree, a neem case. So neem we are using, India is using neem. Neem is not new to us. कफ कोल्ड हो गया तो नीम यूज करो, स्किन डिजीज हो गया तो, और डेंटल के कुछ तो दांत दुखने लगा तो नीम यूज करो. फॉर इंडिया नीम इज an integral part of life. American company, what it did, it went on for application of patent, saying that neem, we found that neem is used as a method of controlling fungi in plants by using neem oil. We are going to patent this product, neem oil. India strongly opposed it, and fortunately, very fortunate for India, India said we already had this. We have documentary evidence. India showed documentary evidence to European Patent Office, we granted the patent, and ultimately in the year 2000, this patent was revoked. Patentee appealed, appeal was rejected, so it was ultimately decreed in our favor. Same was the case of turmeric. Turmeric in kitchen as a medicine, we use it. कुछ लग गया तो heal wound करने के लिए, जख्म भरने के लिए we use turmeric. Patent was granted. India strongly opposed it, and saying that it lacked novelty, new thing. We were knowing it through ages, since ages. Sanskrit text was produced as evidence. In that it was written, लग जाए तो हल्दी लगा देना. Our grandma is saying us all this, but unfortunately India did not initiate first. ये knowledge जो rare है, no one codified it, ये चला जाएगा. So India realized it at later stage, and then India started preparing traditional knowledge digital library. ऐसा कुछ भी formula हो, government immediately feeds it in this system. And this system is called traditional knowledge digital library. Had the information about turmeric and neem been documented in electronic form and also available to patent office, conducting the patent search, it would not have been possible to award the patent in first instance, first place. There has been efforts after such incident to document traditional knowledge in India. By no means an easy task, which is available in dozens of language and scores of deletes. See now, brand value, everything about brand value. See, Google, Microsoft, see the brand values in billion USDs. Today, Google बच्चा बच्चा जानता है, Coca-Cola बच्चा बच्चा जानता है. They spend countless money on just branding about their products. Infringement, see, infringement, whenever an intellectual property, which is a creation of hard work and mind, if that is infringed, you have remedies. You can get order of injunction, temporary or permanent. Injunction means to stop, refrain, or court will say, court will grant you the injunction, means it will stop the other party, infringing party, from using it. Court will also give damages to you if you have suffered, and also account of profit. If that infringer, yes, he has sold the product and has received profit out of it, then court will award you that profit. And in criminal law also, if there is gross violation with criminal intent, then prosecution will be lodged against you. Now WIPO, just I will cover it. Before it, WIPO, just now hardly it will take 10 minutes more. World Intellectual Property Organization, WIPO. Why was the need to form WIPO? That is very important. World Intellectual Property Organization. Before this, I would like to draw your attention to the history. There was a League of Nations first, wherein each country were different. I am great, I am great, I am great. Need was felt to come together and do business. So they formed a League of Nations. Members were very limited, but there erode two world wars, World War I, World War II. League of Nations was ultimately dissolved. After Second World War, parties became realized that yes, now there is a need, we have to come together. So United Nations was formed after the World War. After the Second World War, United Nations were formed so as to prevent such wars in the future. Same, United Nations covers many branches, same as like for trade between the member states, GATT, that is General Agreement for Tariff and Trade, was formed in 30th October 1947. Now GATT was there, it was just an agreement. Now this GATT was converted into World Trade Organization from 1st January 1995. And on this day only, there was a birth of TRIPS. There was a birth of TRIPS. See, TRIPS speaks about intellectual property. It is an agreement. Before that, what is WIPO? WIPO established in 1967. Year after GATT. After GATT, this was established. GATT converted into WTO. In GATT, at the time of the GATT, WIPO was established. It was nothing but a organization having member states. India was a member state. America was a member state. It had 193 member states. They were signatory to it. What is the need? World Intellectual Property Rights Organization to protect the idea, the intellectual property in all parts of the world, at least between these member states. So I cannot apply Google symbol in India because Google is well known. Google is situated in America. I cannot use Google on my product because India is a signatory to WIPO. India has signed and has accepted that yes, in India we will take utmost care through laws that a trademark of foreign country is not infringed in India. So WIPO is a global forum for intellectual property, service, policy, formation and cooperation. We are a self-funding agency of a United Nations. See, United Nations. After World War, United Nations was formed. That was the main body with 193 member states. WIPO mission is to lead the development of balanced and effective international IP system that enables innovation and creativity for the benefit of all. WIPO mandates governing bodies and procedures which set out in WIPO convention. Now, when we see the WIPO conventions, there are articles. Article says, yes, member state, you enact law in your country to protect patent, to protect trademark, to protect confidential information, to protect copyright. This same is there. India, by signing on it, has taken a responsibility that yes, we will make sure the property of other member states are not infringed and are protected in India. Headquarters at Geneva, Switzerland. Now, agreement, that is TRIPS, born in 1995. Agreement on trade related intellectual property aspects of intellectual property rights is an international legal agreement between all member nations of World Trade Organization. TRIPS agreement is to date the most comprehensive multilateral agreement. All the members of WTO, that is 164 member states, are also the party to TRIPS. TRIPS set down minimum standard of the regulation by national governments of many forms of intellectual property as applied to nations of other WTO member nations. Example, I'm giving an example. Article 39, what it states? Article 39 of the TRIPS states provides the protection of trade secret by member nation. These nations are under obligation to protect undisclosed information and data submitted to the government or government agencies. The nations must enact and enforce law so that natural and legal person, that is company, have an opportunity to prevent disclosure of information lawfully within their control. It applies to confidential information and trade secrets which have commercial values. Same will be there in case of copyright. Same will be there in case of patent, trademark. So by signing on these articles, this agreement, India has taken up a responsibility. Yes, we will enact a law in India so as to protect the trademark, intellectual property of other member nations. Now, just I want to show what this can do. Google, see, book value. Book value means assets on the books. Google has assets of 19 billion USD. But see the market value. Market value is 197 billion. Why is it so? Only 10%. Book value is only 10% of the market value. The difference is the intellectual property. Google may be having less assets, but the brand value is such that suppose I start manufacturing a local phone, local pay vocal, local phone, and just what I do, I come up with a sticker and of Apple and paste it to my mobile. Now it is an Apple phone. Anyone will take it for at least 10,000 rupees. This is the brand. Apple phone. When you take the product, you will blindly follow, because you know what the brand it has created, what the reputation in the market it has created. There are very few person who complain about the quality of the mobile phone. Okay, then what you can do now, how you can convert your intellect into money. The second part of my this webinar. If you have a brand in your mind, I request you go and register it. See, one Chirag brand is there. I have a brand. My name is Chirag, and suppose Abhishek, my friend Abhishek, I come up with Chirag firm. Abhishek will get dissatisfied. Why you have kept word Chirag? If I give name Chirag Abhishek, then I will not be protected. Then let's come with some innovation. Keep the word CA, AC, both will be happy. ABC, anything. Brand can be anything. Easy to spell, not related to product. Some criteria are there. If you have brand, please register it. You advertise it. Advertise as much as you can. On the bottom left side, you can see my logo, ants and bees. This is not my registered brand, but ants and bees is my registered brand, which you can see on the first page. Ants and bees is my registered brand. I thought ants and bees both are hardworking living things. Both are hardworking. Both work in teamwork. So I've thought it fit to register the trademark ants and bees. You won't believe it. Many person have from the corner of India have asked me, your trademark is very attractive. Rather, I am known for using this trademark ants and bees. Easy to spell, sweet to spell, ants and bees. So if you have some idea brand, you register it, you advertise it, so it will create brand value. Suppose I have a small bag and I paste Gucci or Adidas. Immediately you can imagine the value increases. Woodland value increases. The product is the same, but it assures quality. If you have some invention, please do register it. If you have in Chiprun, I heard Chiprun is also called as a adobe of Lord Parshurama, if my memory thinks fit, and also known for vada pav. See, if you have some products like Alfonso Mango, you can meet associations and request them to opt for geographical indications. This will add value. This will create revenue for your town, your city. If you have some literary work, dramatic work, you have written some script, please do register under Copyright Act. You can do wonders after by registering these marks. Only I would like to lastly say, please throw out the thinking, कुछ तो लोग कहेंगे, लोगों का काम है कहना. Don't ignore them. As Mahatma Gandhi had said, first they will laugh at you, ignore you, fight with you, then you win. So कुछ तो लोग कहेंगे, लोग का काम है कहना. So you jot down your vision on the paper, you create your brand. Intellectual property can make you famous in a single day. You will just enjoy royalty. If you have idea, please don't just keep it as an idea. You take up further steps. Okay. Last, I will play this video and I will stop.
कुछ तो लोग कहेंगे, लोगों का काम है कहना, छोड़ो बेकार की बातों में कहीं बीत न जाए रहना.
Okay. Last slide. What of your famous the what do you call it as favorite of many? Thank you. Okay, I thought this is the end. Hope you have enjoyed this webinar.
Thank you, Chirag sir, for acquainting us with intellectual property right, converting intellect into money. It was indeed and relevant information for all of us. So without further ado, let's quickly move on to question answer session. But since we are running with short of
Yes,
time,
yes.
few questions will take. And the first question is, can we take copyright of lectures recorded for our college students? From Rupesh sir.
See, first of all, this lecture I spoke, or lecture we professors give, it is not a intellect. The only thing is we are sharing from various sources. Today I have delivered this lecture. Majority of this my part was covered from books of different authors and from different sources. So I am not reiterating what already has been stated by me. It is not my creation. So lectures and other things cannot be copyrighted, as it is only just for uh, educational purpose. Yes, but if you from your own research, if you set out other examples, new examples, then surely you can very well copyright it. Okay.
Thank you, sir.
Okay.
And the next question is,
Yes.
some product need to be patented in different countries again?
No, see, for that only, yeah, the answer is yes. You have to file patent in every country. That's why patent cooperation treaty is there. If you file this patent application under patent cooperation treaty, no need to go to other countries and register. It will be registered in every member state who is the signatory of that patent cooperation treaty.
Okay. Thank you, sir. Next question is, give information about patent agent examination for our students.
Patent agency, patent one whole chapter is there. Patent agent, the qualifications from science background is required as per a little knowledge about it. I know the science, because ultimately the invention, you have to register one invention. One entrance exam is there for that, and one main exam is there. If you clear it, then they will give you a designation of patent agent. Yes, patent agents are very helpful in they help you in filing and doing all the documentation which is required for getting a patent.
Okay, sir. Now we'll take last question.
Yes.
Can we use mnemonics tricks as copyright?
Yes, you can very well use it. See, but criteria are there, but you can use it. Okay.
Thank you, sir, for patiently answering all the questions. Thank you once
My
again.
pleasure.
Now I request all the participants kindly note feedback link will send you in chat box of YouTube and Telegram and Zoom. Please fill a feedback form. Thank you. Now I request Mrs. Neha Tambe ma'am to come in and proceed further to propose vote of thanks.
Thank you, Archana Madam. On behalf of IQAC and Department of Commerce of DBJ College Chikun, I take this an opportunity to propose vote of thanks for today's webinar. I would like to extend my deep thanks to our today's resource person, Advocate Chirag Sonecha sir. Explanation about patent, trademark, copyright, trade secret, design were excellent. As you said during presentation, invitations are necessary for the existence and survival of mankind. In today's situation, it is absolutely true. It is indeed very interesting and informative session for all of us. I would like to express my sincere thanks to any society, Principal of DBJ College, Dr. S.S. Bar, Vice Principal of Science, Dr. Gavai sir, Vice Principal of Arts and Commerce, Dr. Chanda sir, IQC Coordinator, Dr. Shilpa Sapre Bharmal Madam, for their support and inspiration. I would also extend heartful thanks to technical team who has immensely helped us for technical aspect with which webinar turned successful. Because webinar like this cannot be organized overnight. It requires meticulous planning and have worked for this. I would like to thank all the participants without whom webinar would not have been possible today. Thank you participants for joining with us. Participant kindly note that the certificate will be generated within 4 working days to only those participants who have submitted feedback form. So kindly request all the participants to submit feedback form. Thank you. Stay home, stay
Thank you.
safe.
Thank you very much.
One kill.